Welcome back to the Cordell Cordell Virtual Town Hall. I'm Scott Trout, CEO of Cordell Cordell, and we continue to bring you information for guys before, during, and after divorce, and today is no different. And as we always caution, make sure this is not legal advice. It's educational, informational. Nothing can replace a consultation with an attorney, particularly and especially one who practices exclusively in family law, like the attorneys at Cordell Cordell do. If you want a consultation, after sitting through this and have questions, we're certainly available. You can do it virtually, just like this, utilizing any of the methods, WebEx, Zoom, FaceTime, whatever it may be, on the phone or in person where appropriate. You can find us on the web, CordellCordell.com, or give us a call, 866-DADS-LAW. You can schedule a consultation. It'll be a great investment of your time. Today, we're going to talk about something unique in divorce for men over 45. About 15 or 20 years ago, we've been doing seminars around the country live prior to COVID, and spotty here and there when during COVID. But one of the things we found is that guys who were attending some of our seminars, 10 Stupidest Mistakes Guys Fake, or the divorce workshop for men, a lot of it was focused on custody. And particularly for guys over 45, that may not be an issue, or they may have a business, or they may have other issues or concerns that don't necessarily relate to a larger segment of the population. So that's what we're doing today. Divorce for guys over 45, because each of them bring with that a unique issue, a unique perspective, and obviously a unique strategy. So we want to answer your questions as well during this, and we're going to devote some of the time in the second half of our town hall to answering your questions. You want to submit those right now in the chat box. We'll get to those in the second half. So make sure just to put your first name, your state that you're living in, and that way we can try to direct it to perhaps a member of the panel today who's with us and try to get you some information. But do that in the chat box now as we go along. We'll continue to monitor that as we move forward. You can also send your questions if you don't want to ask them live. You can send them to townhalls@CordellLaw.com. If you haven't subscribed or listened to our podcast, you want to do that. You go to Apple iTunes, you can go to Cordell Cordell or Men's Divorce Podcast, and you subscribe. We'll do an alert twice every week with a new topic that lasts 10, 15 minutes, real quick, get you some information, and really get you equipped to have a conversation with an attorney and to ask the right questions. So you want to do that. Subscribe to the podcast and listen to it. So some of those questions you may submit at townhalls@CordellLaw.com will be answered during that podcast as well if we can't get to those at the end of our virtual town hall. So let's go ahead and get right to introducing our panelists from Cordell Cordell today that'll be joining us and kind of navigating through divorce for guys over 45. First in Mississippi, Jerrod, welcome.
Hi, I'm Jerrod Rayborn. I'm a litigation attorney here in Ridgeland, Mississippi, and I've been with the firm since January of 2018.
All right, hey, Jerrod, I want to make sure we could hear you. But anyway, we'll go ahead and introduce Josiah over in Colorado.
Hello, my name is Josiah Silverstein. I am a litigation attorney here in Denver, Colorado, and I have been with Cordell for about a year now.
Thanks, Josiah. Sorry, I lost the audio and I got it back now in my earpiece, so I appreciate it. Here, I thought I was losing my mind. All right, Danielle over in North Carolina, welcome.
Hi, Scott. My name is Danielle Webb. I'm a litigation manager in our Charlotte office. I've been with Cordell for almost 2 years, but I've been practicing family law for about 10 years.
Thanks, Danielle. Wrapping up the panel, going to Nebraska, Alyson, welcome.
Thank you, Scott. Alyson Ryan. I'm an attorney at the Cordell firm here in Lincoln, Nebraska. I've been with Cordell since April, actually, and I've been practicing family law for a few years now.
All right, thanks. So get your questions in now and get in line. We'll address them as they come in and devoted to the second half. We call our lightning round. We'll be very quick, under a minute, try to get you an answer, get you some directions. Again, not legal advice. So also get a piece of paper, pen, take some notes. It'll serve you well when you have a consultation with an attorney. It's certainly worth it. So let's get to a real quick break. We'll be right back after this message.
New school, new job, new home. Change is hard and can leave you feeling isolated. And divorce delivers one of life's hardest blows. The relationships you counted on are suddenly gone. But you don't have to walk through this alone. We can help. For more than 30 years, Cordell Cordell has guided men through the challenges of divorce. You're not alone. Call Cordell Cordell, a partner men can count on.
All right, again, questions in the Q&A section, not the chat box. tend to forget. It's so easy when you have that down at the bottom. You want to submit your questions in the Q&A section. We have a few questions that have already rolled in, so keep those coming. All right, let's get right to it. Jerrod, one of the big topics I know when I meet with guys from around the country is, and it's very confusing because every state has some different way of negotiating and navigating maintenance, spousal support, what they used to call alimony. You know, that's the question is, hey, am I going to pay? Especially when guys are 45 and older, or even, and they've been married a long time. That is really the first question. And for me, it tends to be probably more of a concern when I'm meeting with a client. So that's the question. If you're presented with it, Jerrod, we'll have to pay alimony. What do you say?
Well, that's a very difficult question to answer, because Scott, it can't be answered until you've seen their financial declaration and financial information. You know, I can usually give them some principles, such as most people do not have permanent alimony exposure unless they have just a very, very large income, or they've been married for, say, 30 years or longer, because those are certainly the two big considerations: is what is the amount of income and what is the length of the marriage. But it's not uncommon to have temporary alimony exposure. And the first thing they want to know when I tell them that is, well, how much and how long? And again, that's a difficult thing to give them a number on until I've seen the finances. But and the reason for that is this: if you take something like child support, we have a formula. You know, I know they're going to pay 14% for one child. I know they're going to want to pay 20% for two children, so forth, etc. That's a formula. We don't have that for alimony. Instead, we have factors, and that can really lead to some mixed results, just because there's not a magic formula. And
it is. You think about that formula, Jerrod, and it always brings to mind Kansas. For me, Kansas has this formula by, you know, I think it's 120 months or 121 months is the maximum. It's real easy in a state in which you have, you know, really good concrete, you know, a roadmap. Like Missouri, similar to Mississippi, it's very judge discretion. I always say I could have the same facts, the same income, and two different judges and get two different results. I mean, is that your experience?
Very, very much so. In fact, I've heard some people even say that they shouldn't be called the alimony factors. They should be called the alimony justifications, because it seems like sometimes judges just pick a number and then they justify them with the factors. And that's not because judges are not smart people. In fact, they are. It's because alimony has been stuck in a long transition change for a long time now due to societal changes. And you know, that's the primary reason for that. I mean, if you think about the original purpose of alimony when it started in England, was to compensate a female who, when a male had committed adultery. That was the original purpose, you know. But fast forward in society, we've kind of blurred the gender roles now, in that women are dominating in historical male jobs. I don't think you can get a better profession, an example than that, than the legal profession. There's tons of great female lawyers now, but at the same time, you've also got stay-at-home fathers and, you know, stay-at-home dads. And so because of that, alimony is now transitioned into a tool that's available to both men and women.
Yeah, I call it manimony. I did an interview years ago, and I want to say that around 20% of men seeking divorce, we'll call alimony eligible. And we'll go through kind of the general factors, but only single-digit percent of, say, 6 or 7% actually got alimony, when otherwise they should have under normal circumstances. And it's the whole theory of blind justice. And I had a judge or an interview ask me one time, if you could change one area of the law, what would it be and how would you change it? And I said, well, you would have a petitioner A and a petitioner B, and the judge wouldn't know who it is. They wouldn't know gender. They wouldn't know role. They wouldn't know history necessarily. And that really because, you know, we talked about stereotypes, and it's an unintentional bias where you think, oh, the man should be the breadwinner. Well, as you suggested, huge numbers of increases where women are playing huge roles of being the breadwinner in the home. And I think that's so critical. So it always brings up, I guess, the point is, ignore gender for a moment, the factors, length of marriage and income disparity. I think you mentioned those two. Is that primarily what you're looking for?
It is. We use a series of factors here in Mississippi called the Armstrong factors, but certainly those two, length of the marriage and disparity in income, regardless of gender, those are by far the first two things that you're really looking for. And especially when you're talking about not only the amount of alimony, but the type of alimony. Because if you've got there's 4 types of alimony here in Mississippi, and those are permanent alimony, reimbursement alimony, rehabilitative alimony, and lump sum alimony. And permanent alimony is not permanent. I think it would be more properly named if it was periodic. They call it permanent because it doesn't have a definite end date, but it's always subject to being modified or being terminated. And that's not typically going to be ordered unless you have a 30-year marriage. Lump sum alimony is usually used when you have as part of property division. That vests immediately, and it's going to be for a bigger figure, but it's going to be paid in lump sum installments instead of having a constant tie to that person of having to write a check every month. And then the other two being rehabilitative alimony. Rehabilitative alimony is really when you don't have a long enough marriage to justify that permanent periodic alimony, but you do need a transition period for someone to be able to go back to school or to learn a trade. Mm-hmm. But very rarely will you have that one ordered for more than a few years. And then this last one is very rare. In fact, it's only been around in Mississippi since 1995, and that's reimbursement alimony. And that's for a situation to where maybe you have someone that's gone to medical school, and then that new doctor immediately decides to divorce their spouse prior immediately becoming a doctor, and then the spouse that's helped put them through school never got to enjoy the fruits of that higher income of the doctor income. That can be ordered as well, but that one is very rare.
It is. I think for when I write, one of the reasons I wanted to talk about alimony or maintenance is because to me, it's the biggest exposure guys have when you have perhaps the income disparity, the length of the marriage, and because it could be forever. In Missouri, we talk about the types. We just simplify it as open-ended or closed-ended. You can negotiate your way out of it through other property and lump sum payments, but 99.9% of the orders issued here in Missouri are open-ended, which means until death or remarriage or otherwise terminated or modified. Last thing you want to do is continually write checks every single month. And that's why I think it's always good to analyze, what are the factors, and in a state in which may have, exact limitations and trying to calculate exactly what it should be, giving you some guidance. But I think in generally, it creates the biggest heartache for anyone who can't get a formula. And really, we can try to guide you and give you some ideas and what it'll be. But those are really, for me, the kind of the concerns about guys, particularly over 45, is you may be a stay-at-home, wife is working, so you're typically going to see a long-term marriage. You're going to see a disparity of income, typically, and that's going to trigger an analysis of maintenance or alimony. And I think that's one of the bigger concerns. So, Jerrod, thanks. So that kind of walks into the next one, where guys who may be over 45, they may have kids, custody may not be an issue. And so, Alyson, the question becomes, and I think it can be really complicated, is when do I stop paying child support, which also wraps into me a really good conversation about what happens for those states which go beyond age 18 when your kid goes to college. Here in Missouri, you're technically going to continue to pay when they're of age and in college still. There's some avenues to consider there, but generally, when does child support, when can they stop?
Sure. So just a caveat, first of all, I'm licensed in Nebraska. I'm not licensed in other states. So a lot of what I'm saying will be state specific to Nebraska, but a lot of what I'm saying also is general, and it can be applied across states. There's two different avenues to change child support, whether it's terminate or modify. One avenue being there are these events that automatically trigger, for instance, a termination of child support. The other avenue being events that don't automatically trigger the termination, but you can still request a modification based on those events. The automatic events, typically across states, are the same. The child reaches the age of majority, which does differ in states. Most states, that is age 18, as you were mentioning, Scott. In Nebraska, it's actually age 19. The child gets married or joins the military. In Nebraska, we call that becoming an adult. The court calls that becoming an adult. Also being emancipated from your parents by court order. And neither parent is responsible for providing financial assistance anymore to that child. And of course, heaven forbid if a child passes away. Those are what are known as automatic triggering events, which you still have to let the court know typically by sworn affidavit, sworn statement that event has happened, and maybe provide some proof, for instance, a marriage certificate for the child, an emancipation order, a death certificate. And so typically at that point, the court will terminate your child support obligation. The other avenue is things that are not so much black and white, they're more gray matter. For instance, your income has significantly decreased. Or say, for instance, you've lost your job through no fault of your own, you were laid off. Perhaps you became disabled, you can't work anymore, you can't earn an income. These are all ways which give you a foot in the door, so to speak, with the court to file a complaint to modify your existing child support order, asking that your child support obligation be either terminated or deviated downward. Another instance, as you mentioned, Scott, was a child who's now attending college. In Nebraska, it's not an automatic termination of child support, but it is a reason why you might file that complaint to modify, to request that your child support obligation either cease completely or be deviated downward because you are now contributing to tuition. It's another big reason to file a complaint for modification. Another reason might be you're obligated under your current order to provide health insurance for children, but now your health insurance costs have substantially increased. That's going to affect that calculation that Jerrod was referring to earlier, where we determine what your child support is.
I was just asking one question. I think that to me, and it may not be Nebraska, obviously, since it's 19, you may have 1 year of college, but here in Missouri, for example, at one point it used to be age 22, now it's 21, and where you continually pay child support, even when they're in school, having, they have to take a certain number of hours and certain grades. And the question guys always had was, look, my child's living in Massachusetts and I'm here in Missouri and I'm paying for room, tuition, board, all that. And I'm also ordered to pay a full amount of essentially the room and board under my decrease. Why am I required to pay both? Which I always find unique in that we always found ways to either reduce the child support while the child's away from school, or to suspend the child support in those moments, those 6 or 9 months a child's away at school, or a small amount goes to the custodial parent. That's kind of what I see as maybe great opportunities for guys who are going through a divorce and maybe are just finished and have an order, or what do they do? It's interesting. So you may have 1 year lap or a crossover in Nebraska at age 19, perhaps, right?
That's correct. And I do want to mention the courts here do stress the importance of children going on to further education, and they will uphold an order where a dad or mom has to contribute to tuition. And sometimes that is incorporated into an original decree. Sometimes it's not. And the child, who was 2 at the time, is now entering into college. And the question becomes, okay, who's going to pay for this? And then, negotiations, settlement talks might happen, and we come up with a new order where each parent is responsible for a certain percentage of that tuition, and perhaps parent who is paying child support now pays less because, people are reasonable, judges are reasonable. understand there's only so much money to go around.
Yeah.
So, I mean, you're paying X amount in child support, and that may take you to hypothetically right above the poverty line. You don't,
Yeah.
you know, so now where's the extra money coming from to pay tuition? There's just not enough to go around. So something's got to give.
Yeah.
In a lot of circumstances. So you'll see tuition obligation go up, child support obligation go down. But you're right in Nebraska. Go on.
I think it's
Sorry.
complicated. Yeah, because especially in Missouri, and it's the law requires divorced parents to contribute to tuition in college. It's not, there is some discretion, but it's going to be only when you look at the income, and it's not really. I just don't think I'm going to order it. It's a mandatory thing if the court finds that each party can contribute some percent, and that complicates, as you suggest, the amount of available money, paying for tuition and paying for child support and paying for room, tuition and board, or room and board. It's crazy. And so I think that is the best opportunity for guys as we think through it. And so real quickly, go ahead and keep submitting your questions in the Q&A section. We'll get to those here in about 15 minutes or so, and we'll answer your questions. So I guess then the question is it's a modification. I mean, if these are guys who are post-divorce, it's a modification, get with an attorney, kind of go through those factors of whether it's a decrease in income or a change in the child, meaning the child moving away, going to college, and they're still under 19 years old in Nebraska, or 21 or 22, whatever the laws may be in your particular state.
Yeah, and it's very extremely important. I can't stress this enough to get that complaint to modify on file as soon as possible, meaning if you know that triggering event is coming, for instance, you're going to be laid off in a few months, or your health insurance costs are going up, get that complaint to modify on file. Or for instance, you just lost your job, get it on file right away, because that then triggers a termination of the prior child support order, meaning that you're not going to continue accruing an arrearage for your child support that you were paying before. Typically, at the end of this new modification case, the court will generally and typically be retroactive in its order, meaning the date you filed your complaint to modify is when your old child support obligation ceases. So it's
and I think,
to get that.
As you think, and guys who are watching that may be in the middle of a divorce, obviously there are other situations where you may have equal custody, equal earning capacity, and maybe there is no child support. Maybe that's the argument, is each of you have equal time, each of you have equal income, and so there maybe should be no amount that changes hands. And you just agree, hey, we'll split the cost of clothing and other necessities. Those are other options and opportunities for guys to think about in their middle of divorce.
Yeah, for sure. There are a lot of different ways to negotiate. Typically when you go to court, when you go to trial, you're stuck, so to speak, with what the judge orders, and the judge isn't going to put out a unique order, so to speak, and say, well, let's get creative with expenses. I mean, that's just not going to happen. So if you want to try to work something out, the time is before you get to that litigation phase, and try to work something out maybe in mediation or between attorneys with payment of expenses.
So child support, college ideas, Danielle, that brings up the notion of another question, which is frequent. You may have an individual or guy where they've started a 529 plan. They've obviously contributing to a 401k or some sort of defined contribution plan. And they always say, well, should I keep contributing? For me, when we talk about college, I have some ideas, and obviously every situation is going to be different in the facts and circumstances, and a lot of things come into play about standing orders and whether you can change things and whether the action's filed. But generally, what do guys want to consider if they're still putting the max into a 401k and the max into a 529, and they have to think about how it's going to be divided, and they're contributing towards an ultimate division, right?
Sure, absolutely. And when you think about contributing, whether it's to a 529, a 401k, any other kind of defined contribution plan, typically those are contributions that you're making during the marriage with a view towards this will be something we use together going as a family and as spouses to finance things in the future. So when you're getting a divorce, the thinking changes completely, because it's no longer a we, it's okay, how are we going to divide this up? And we've been talking a lot about 529 plans. I'll start there. To the extent you are in a state that requires you to contribute to college and requires you to pay college expenses, then putting money into a 529 plan is probably a smart plan moving forward, even through the divorce, because those funds are going to be used to offset any eventual child support or support obligation you would have with respect to the college expenses. North Carolina, it sounds like, is a little bit unique from our other panelists. Child support in North Carolina ends when you're 18 or graduates from high school, whichever occurs later. And the courts in North Carolina will not require parents to pay for college. So when we are involved in discussions about 529 plans, they are actually considered part of the marital estate and will be divided and assigned to one of the parents as an asset moving forward in the divorce. So to the extent that contributions have been ongoing and the parties can agree or seem to be of a mind that, listen, we're going to just use this money for college and we agree that it'll be used only for college, then I do encourage people to consider continuing to contribute as long as everyone's on the same page there. But it's important to understand that if the page changes and all of a sudden that's an asset that your spouse can portray as, look, that's going to be his asset, that's going to be her asset, and she can take the money and do what she wants. I mean, yes, there will be tax and other implications to it, but that is how it would be viewed by a court, at least in North Carolina. That's an asset of the individual parent who retains it.
Yeah.
When we start looking at 401ks, that's a little bit different because unless you have reached retirement age and are actually drawing from the 401k, there's a lot of considerations that go into, well, do I continue contributing? Any money put, whether it's into a 529 or a 401k during the marriage, is going to be considered a marital asset and will be subject to division as part of the divorce process. So what sometimes if folks are thinking, look, it's December or November, I've maxed out my contributions, but things are not going so great around the house. And I think maybe we might be separating or divorcing. Well, if you've already maxed out your contributions for the year and you decide, okay, well, I think we're going to separate in January, it might be a smart time to think about, well, maybe I suspend those 401k contributions, at least for the short term, because then all you're doing is adding money into a pot that's eventually going to be divided. If you are over the age of 50 and you suspend your contributions for a period, you may actually be able to do a catch-up contribution and make that back post-separation. So if you can sort of manipulate the situation a little bit and hold off on contributions and then make it up later, that might be a smart way to do it, especially if you can read the tea leaves and see we're probably going to be separating this year or in the first part of the year, things like that. Obviously, when you get into 401ks, IRAs, you definitely are going to want to consult with your financial advisor on that. There's going to be some potential tax consequences and other things. But the big key takeaway, whether it's a 529, 401k, IRA, is that any money you put in that particular investment vehicle is most likely going to be considered a marital asset and subject to distribution through your divorce. So you need to be a little bit wary and mindful of how is this going to impact me going forward.
There are, interestingly, as we've been doing these virtual town halls and the benefit of having attorneys across the country, and I think, I can't remember if it was California or Arizona, where they talked about the status of marital properties defined as of the date of filing. So it may impact whether or not you can and not really jeopardize your future contributions. But as you were talking about college and a 529 plan, like one in our state, where you're going to be paying, and it goes until 21, and the court's going to likely order you and your spouse to contribute in some fashion, just thinking that if I'm the only one contributing to 529 and it's ultimately going to be divided, let's just call it 50-50. Well, it's really not 50-50 because she's getting 50% of everything I just put into it. And so now I'm having what is really mine. And so you just have to be wary about it. And I think the caution is standing orders. If you're in the middle of a case and it's been filed, then obviously there can't be certain changes to certain contributions and way you're doing things. So we always talk at great lengths about strategizing prior to filing and then carrying on that strategy during the filing. But I think this emphasizes, as you may suggest, is get with an attorney. Let's take a look at what you're doing and let's make the best case for it. And it would be meaning that you're consulting and collaborating with a financial advisor or someone, because you're giving up some tax advantages. And you just have to weigh the benefits of the decision, because every decision that you make has an effect on not just in the case, but in your financial situation in general, which is really interesting. But the whole idea that 401k, and I've recommended to clients in the past, and I'm curious if you, is to say, let's just stop for now, because 50 cents of every dollar you're putting in is going to her anyway. And 50 cents of every dollar that's in there is going to her anyway. So why continue that in that direction?
Yeah, absolutely. And, I discuss that with clients all the time. And in particular, because in North Carolina, we have a very long period of separation to 1 year before you can file for the divorce. So we actually calculate the asset division as of the date of separation, which means that we're often negotiating and dividing assets during a period of time when the parties were separated but not divorced. And so, yes, absolutely. We talk about suspending contributions. We talk about, you can't force anyone to do anything, but strongly encouraging the spouse to start contributing as well, so that it is more equalized when you go forward. But again, it's going to depend a lot on what, A, if you have any orders existing in your case, obviously, and B, what your state's law is requiring your legal obligation as a parent to contribute towards college. One thing I would certainly say, you never want to, if the court order tells you you need to be doing something, you obviously don't ever want to do anything to subvert that, even if it's, it can be characterized as something innocent, because in general, the court will not view it as an innocent change to a tax planning strategy there. That's not going to play well for you.
Yeah.
So.
And I think, we can make this sound very simple when we talk about math and, oh, you're giving 50 cents of every dollar. But I think the opposite, and we were, just talking with Jerrod about maintenance, is that the effect of not contributing to a pre-tax retirement vehicle is now your net income is increasing. Now you have more net available money to contribute towards child support, maintenance, attorney's fees. So it is far more complicated. But I think the reason I wanted to talk about it is it's worthy of a conversation, because again, you may have a different approach and strategy based upon the facts and circumstances, and you may be a maintenance candidate already. So whatever you choose to do is not going to affect it, and it's just actually going to help you on the property side. And that's why I think what we see, and why I wanted to raise it, was you see a lot of attorneys that just don't even talk about that subject. And I think it's it's very important to at least talk about it, and then let's work through the problem. Let's figure out what the options are, and then ultimately you make the decision. So it's a good one.
Yeah. Well, and you make a great point, Scott, as well, that, sometimes, in North Carolina, for example, your retirement contributions, even though they're coming out of your check, are still considered in your gross income for calculating child support and spousal support. So that's a very state specific, probably, distinction. And if your state looks at net income, you could potentially really sway your spousal support obligation by increasing your retirement contributions. But in many states, it's a gross number. So bear that in mind as well. You might be taxed with child support and or spousal support based on a gross income number. And when you say, but I'm putting $1,500 a paycheck in my 401k, that's not going to get a very sympathetic response.
Yeah, agreed. Josiah, let's talk about misconduct. I know this one, I can tell you from experience, we've talked about it with other attorneys around, Cordell, from across the country in different states, and it varies wildly. I think, here in Missouri, albeit a lot of clients hear this idea of no fault, in which they automatically think that they can't raise certain issues, but in Missouri, misconduct matters. I can skew. There's a case out of, I think, the Southern District of Missouri that talks about a 90-10 split in property based upon misconduct, whether that's adultery, financial, whatever it may be. So here it matters. Here we use it. Let's talk about Colorado. Does misconduct matter in Colorado particularly?
Well, Scott, I'm glad that you raised the issue of no-fault divorce states. This is something that is becoming more and more common throughout the different states. But like most aspects of a divorce case, whether or not marital misconduct can impact, for example, the division of property, depends on the specific facts of the case. So in a no-fault state, you don't need to show misconduct on the part of one party or the other in order to obtain the actual divorce. The court needs to only make a finding that the marriage is irretrievably broken, for example, here in Colorado. Colorado does require what's called an equitable division of property, which isn't necessarily a 50-50, but it is based on factors such as each spouse's contribution to the acquisition of the marital estate, including contributions as a homeowner, the value of each spouse's separate property, economic circumstances, and a number of other factors. However, just because Colorado is a no-fault state does not mean that misconduct won't be held against you, especially when it comes to the issue of marital waste, which is spending marital property, marital funds on something that does not benefit the marriage or the family. So for example, the fact that one party or another had an affair in and of itself would not necessarily impact the division of the property. However, the court would consider marital funds that were spent on that affair, travel, restaurants, gifts, hotels, things like that.
If we talk about misconduct, I think what's interesting is, I always think about unique laws around the country. Georgia has one we talk about equitable division of property, but misconduct in general related to spousal support. Last time I was licensed in Georgia, I practiced for many years. And back then there was a provision that if I could prove that the cause of the breakdown of the marriage was as a result of an adulterous relationship, that would serve as an absolute bar to spousal support. So a misconduct mattered hugely at that point.
And that is why it is so important that for questions like this, the information that the attorneys here are given are very specific to the individual states in which we practice. And there are so many different factors that vary from state to state, in particular regards to misconduct, that it is vital that you do consult an attorney who practices in the jurisdiction.
I was just using, speaking of, misconduct, I was just using, and I'm curious what you do in Colorado. We were getting ready to try a case, and I was going to introduce evidence of the lack of response on our offers to settle the case. Generally, as a rule, settlement offers are not admissible as evidence at trial, but I was using it to show litigiousness, which, meaning that either the attorney or the attorney's client wanted to do nothing but drive the cost of litigation up by not responding to settlement offers, not making settlement offers. I called that misconduct, litigation misconduct, and I wanted attorney's fees because of it. Is that something that, clients you see, particularly at this age, when we're talking about perhaps assets and you're going to drive up the cost when you were looking for an equitable division for guys over 45?
That is absolutely something that the court will consider very strongly when determining a division of property or a maintenance award. The conduct or misconduct during a case, especially if that misconduct causes the other party to incur additional attorney's fees that they would not have otherwise had to incur, then I have definitely seen this where the court has ordered one party to pay the other party's attorney's fees specific to those attempts in order to get that cooperation or to get those discovery responses, those financial disclosures, wherever that misconduct is. Attorney's fees can also be ordered for filing or defending what in Colorado the standard is a groundless, frivolous, or vexatious filing, or groundless, frivolous, or vexatious defense to a filing. If you're filing a motion, or your soon-to-be ex-spouse is filing a motion that has no legal or factual basis, just for the purpose of driving up those attorney's fees, then the court does take that misconduct during the course of the proceedings very seriously.
So here in Missouri, I can introduce evidence of misconduct, adultery, whether it's physical or emotional. I can introduce evidence on financial misconduct, gambling, alcohol use, drug use, physical abuse, general misconduct about, whether it be just, emotional abuse, just terrible behavior during the marriage for a number of purposes. It could spill into child custody. It definitely spills into the division of property where I may want more 60% or more. It spills into the cause of the marriage breakup and therefore spousal support. I mean, that stuff is coming in every single case, and it's in the discovery phase. Can you do that in Colorado? It sounds like you're just, unless it's some extreme impact financially, you can't introduce it.
Well, it can be introduced if it's relevant. And there are definitely ways to make those arguments that those factors are relevant. However, Colorado is generally, as far as the division of the property goes, Colorado generally goes by that equitable division of property based on those specific factors. I will tell you that here in Colorado for maintenance, for example, maintenance is calculated using a very simple formula for the guidelines. It's the lower earning spouse gets enough maintenance so that they are earning 40% of the combined gross income between the two of them. There are a number of factors, as I had stated before, that the court considers when implementing an actual maintenance award, but misconduct during the marriage is not one of those factors that the court would automatically consider. However, in extreme cases, that may very well be the case.
So thanks, Josiah. Brings up kind of, the issues, Danielle and Jerrod. I'll come back to you as we get closer to taking some of these questions that were submitted. I was just meeting with a client who's been separated for 6 years, and, it's a long time, and they really kind of sat around, did nothing. And there's a lot of risk to waiting. Guys here watching, facing divorce, Danielle, what's the first thing, do something?
Well, the first thing you need to do is talk to a lawyer and figure out what the landscape looks like. Best, it's sort of like the sports adage, your best offense is a good defense a lot of times. And the best defense comes from knowing what the offense might throw at you. What are the landmines out there? What are the things I need to be worried about? What are the factors? And that's when I'd say 95% of our consults that we do, initial consults, when clients come in, prospective clients come in, is the first question they have is, I have no idea what is going to happen or what I'm looking at or what the risks are. And that's the very first thing you can do, is figure out what are you facing? What are we up against? What is a game plan we can put together? And a big piece of that often is a financial component, especially with clients who are over the age of 45. How do I protect my finances? How do I reallocate money and contributions and things like that to number one, make sure I'm doing everything I need to do under the law with respect to my children and with respect to my spouse. But at close 1A is, I also want to protect myself, understanding that going forward, I am going to be giving up a lot. And how do I protect myself, as best going forward in that process? So absolutely, you need to be proactive.
Yeah, proactive. I mean, I think there's a lot of guys watching that are in the middle of it. There's a lot that, strategy doesn't end when the case starts, but it's certainly helpful when it begins, in terms of making sure you're making the right decisions of all the things we've talked about, and 401k and 529, and it doesn't end at that point. And I think it's important to just kind of get that basis to understand that there's a lot of things that should be happening and being proactive. And this gentleman who had been separated for 6 years, there's a lot of things I wish he would have done in the interim. He exposed himself to a whole host of potential alimony issues, and the length of the marriage is now much longer than it was beforehand. And so, curious, Jerrod, strategy wise, is that something you want to have a consultation with your client to just sit down and say, hey, here's what we should be doing. Here's the steps you should be taking before you file for divorce, or even though you're in the middle of the divorce?
Being proactive is definitely important in the divorce realm. But, Scott, we handle a lot of paternity actions as well. Mm-hmm. And being proactive is super important, I think, in the paternity actions, even more so than the divorce actions, because typically you've got a situation to where a lady is usually keeping the children and dictating all the shots. She's telling the male, this is when you can see your child. This is the hoop you're going to have to see him this long. You're going to have to pay this. You're going to have to do this. And you need to get something filed. And all of a sudden, you take back some control. You file it, you set it for a court hearing, and all of a sudden, they're no longer dictating every single thing to you. And it's amazing how often just a simple filing will all of a sudden, you'll start getting to see the child and start getting to see visitation. So, and the other thing is, if you file first, you get to put on your evidence first.
Yep.
The judge is going to hear your story first. You know, when things are being presented, they're going to be slanted one way or another, and you can't unring the bell. And the
Right.
judge is only going to hear the actual facts of the story one time. And I think it's worth it for you to be the first one. And Scott, if you don't mind, could I make a quick comment on the misconduct that we
Yes,
were talking
please.
about earlier?
Yep.
I was talking about alimony, and you know, alimony has really been affected by societal changes, and the biggest societal change of alimony is the invention of no-fault divorce. We still don't have it here in Mississippi. We do not have no-fault divorce. We have what a lot of people mistake as no fault, called irreconcilable differences. But because of that, you know, it goes against the spirit of no-fault divorce to really consider fault when it comes to making alimony awards. And so now misconduct is usually not an automatic disbar. Sure, it can have an effect, but it is definitely lessened when it comes to alimony. But in my state, where we don't have no fault divorce, you know, fault can certainly have an impact in those awards because it doesn't go against the spirit of our divorce ground laws.
Yeah, right. Agreed. Yeah, I think misconduct is overlooked, and it's certainly, you know, everyone thinks they get confused with that. And I think that's an important distinction. We talk about no fault, and some of these states have, you know, don't have it. And it again emphasizes what we're talking about, being proactive, having conversations, taking these notes and getting questions answered for you so you can make the right decision for your case. So let's get to the lightning round. We have about 10, 12 minutes left in our day this afternoon. And so let's answer some of the questions that we have coming in. So you can keep submitting them in the Q&A section right now. We'll get to those questions. Let me just take the first one. It's sitting here at the top of the list for me. Cordell Cordell talks about being a great advocate for men. What makes it different for men versus women? Why are we much better than any other firm? What issues do we address better than, in quotes, her firm? And I'm taking that just because I've talked a lot about this and why Cordell Cordell in the past, and I liken it a lot to doctors. You know, every doctor goes through medical school, and every doctor takes their board, and those that can pass their board are competent, and they can be a very good general practitioner. But we have doctors have these unique subspecialties, whether it be oncology or pediatrics or you know, whatever it may be, you know, in terms of focusing on elderly. And I think what's important is they do that for a reason, because they see this is what they focus on, and they see repeat after repeat of different types of matters and cases. And what they do is through that, in those years of practice, you start accumulating different strategies how to treat a patient, and you see what works and you see what doesn't work. And your focus is hyper-focused, not on a general practice where you can see bankruptcy and criminal or just generally all divorce like we do. And so, you know, having the benefit of offices around, you know, the country in 37 states and 300 plus lawyers now in the United Kingdom with 4 solicitors there, is that over the last 30 plus years, you know, in hundreds of thousands of cases, you see perhaps representing guys, you see a lot of the strategies deployed and employed against guys. And you see ways in which you can position your client, whether it be a strategy to get alimony, whether it's a strategy about being involved in your kids, where we talk about the 10 stupidest mistakes guys make when facing divorce. You wouldn't get that if you had a general practice. You may get a small sampling. But see, doctors got it right by saying, I can do, you know, a lot of things great or wonderful, or I can do a smaller subset of my medicine practice really in a very expert way as a doctor. And so we took that and we looked at it as saying we can represent guys, and every day across the country, our lawyers are shooting emails, and we're not bound by these lines of the state where we're saying, here's what I've got. What do you think? Here's what I need to do. What do you suggest? And we get 300 lawyers kind of giving their ideas across the country and using their experience representing guys and trying to put forward the best possible strategy. So yeah, I think we're better than other firms that do a general practice. And we can represent men in that way because that's our focus, and making sure we see every strategy that's out there that we can employ and what works and what doesn't work in terms of what's received. Taking COVID, for example, we had to pivot in certain ways, and with guys who weren't getting the custody they were getting, or money, child support modifications. It just affords us an opportunity where we can be focused on what affects guys most. So yeah, I think, that's what brings the advantage to Cordell and Cordell. There are a whole host of other things that focus on customer service, the ensuring that we're giving updates, to the clients, returning calls same business day, a lot of things that really focus that others don't. So I wanted to just address that to get that kind of taken care of. So let's just kind of go real quickly. Danielle, I'm going to toss you the first question. Sean says, are subpoenas in custody cases worth it? My ex is communicating to my daughter 17 years through, though the separation started when she was 15. And thus this has been going on for some time, even before separation. Numerous proofs of alienation and disparaging comments. She's filing for full custody for all four, with her as the oldest. Would getting a subpoena of the text messages between them, which would definitely show further alienation and disparaging comments against me, have much weight versus effort of getting them? And Sean just happens to be in Virginia, but I've talked about parental alienation quite a bit in our virtual town halls, but I'm curious what you think, Danielle.
I think in general, subpoenas are a very useful tool in divorces, not only in custody, but in other financial realms as well, in order to get information that is out there, but that the other side is probably not going to give you voluntarily. Now, subpoenaing a phone records and in fact, specific text messages and things like that can get tricky because you're dealing with the phone company, which is often reluctant to give up that information. But absolutely, if you can subpoena phone records and that those phone records reveal communications between your wife and your daughter that are disparaging to you or that are, portraying you in a negative light, that's absolutely great evidence, particularly when you're in a situation where your daughter, if she's, taking mom's side, is probably not going to step forward and say, yeah, mom says all these awful things about you. Generally, you're going to hear about the awful things that mom is saying from younger children who don't really have as much of a filter, and they're going to say, well, mom said you did this and mom said that. And that often tips dads off and parents off that the other parent is speaking ill of them, bad-mouthing them, alienating them when it comes from the younger children. But specifically with respect to subpoenas, if you know the information is there, you're probably not going to get it any other way than by issuing a subpoena.
Yeah. And I think you have to look at subpoena, for example, in that case as twofold. One, am I going to use it at trial? And two, can I use it to negotiate a really good settlement?
Right.
I mean, that's really the power. We always say, I want to get everything I can to try to convince them to settle the case, because it's in our interest to try to get a really good deal for our client, but we won't be afraid to try it if we need to. So I think it's really important. And I would say absolutely move forward with the subpoena, but talk to a lawyer first. Let's go to Alyson. It's from Nebraska. In Nebraska, do they look at misconduct? We talked about misconduct here. Do they look at misconduct? Does it matter in divorce?
It's a no-fault state, so in that sense, no. But in regards to custody, in regards to division of marital assets, when you talk about gambling, when you talk about spending money on seeing prostitution, I mean, those kinds of things. That's why we subpoena credit card records, bank statements, to see, what are you spending money on? Those things can cause great exposure with regards to division of assets. And then of course, in regards to custody, it just speaks to, what's your level of judgment? What decisions are you making, and how would that relate to the children? Are you bringing people around the children that are dangerous, even if you're not partaking in what they're doing? Are the kids being exposed? And it really speaks to an individual's level of judgment.
Yep. All right, Josiah, we're going to get you one out of the UK. And so this is from Tim in the UK. And Tim, as you're thinking or listening to kind of hopefully our guidance here, I'll direct you to cordellcordell.co.uk, cordellcordell.co.uk. You'll find more information about our solicitors over in central London, and you can always schedule a consultation with them as a follow-up. I would suggest you could do that even virtually with them. So cordellcordell.co.uk. So Josiah, we can just kind of generally, because I think my experience when I travel to the UK and meet with our solicitors, is the same issues that guys have in the UK are the same issues that guys have in the United States. And practically speaking, the laws are pretty close to the same. There's just a different way of approaching it, that the justice system there works far differently than it does here in the United States. But the question for Tim is, they're selling their marital home, but wife wants 100% of the equity in exchange for relinquishing rights to his pension and future inheritance rights. He's happy to concede some, but the question is that something we talked about, lump sum? We've used that word. Is that something that you would typically have a conversation with the client about exchanging, one thing for the next to kind of get rid of a pension? But for me, and I want you to comment, there are a lot of things that come into play: taxes and valuation, and making sure that you're valuing them equally. To understand pre-tax, post-tax, the UK may have some different issues with their national pension system. So just your thoughts.
So my thoughts on this one are that most of my cases will actually reach some sort of settled agreement as opposed to going to a contested hearing. A lot of my clients prefer reaching that settlement for the obvious reason that a contested hearing is very expensive for both parties and converts a lot of the marital property into attorney's fees, which is not good for our clients. So we do encourage settlement and creative ways of coming to that settlement agreement. While I'm not familiar with UK laws, and I can't advise you specifically to this, if this was a situation that I was dealing with here in Colorado, I would advise my client that we can absolutely do something in exchange for equity in the home, and in order to prevent future liabilities and future exposure. We would definitely want to make sure that we have a full and clear valuation of the home that would require either a professional appraisal or the parties agreeing to use one of the several websites such as Zillow is becoming a very cost-effective way to get around the cost of an appraisal. As far as the future inheritance, my concern about exchanging a future inheritance is that inheritances here in Colorado are considered separate property, especially if there's no commingling of those funds after they're received. So even if you receive an inheritance or a gift during the course of the marriage, that does not necessarily automatically make it marital property. So I would be very cautious about exchanging separate property, giving up any separate property in exchange for relinquishing marital property.
Yep. All right, we got a couple more minutes here to answer questions. Jerrod, Michael in New Hampshire says, my wife was having an affair for over 2 years, and she told me about it shortly after I received a substantial inheritance. She moved out 4 days later. Can those be considered personal, separate, and not marital property?
Well, if in Mississippi, inherited property does start out as separate property, and it can be commingled, but unless it's commingled, that's probably going to be considered separate property, and he's probably not going to be entitled to a portion of that. However, in Mississippi, although he's probably not likely to have a stake in that particular property, weirdly, that property still can be taken into account in the overall pie of property division. So I know that kind of sounds opposite there, but I would say that if that set of facts were in Mississippi, he would not be able to get that property, but it could be counted in her half or as part of what she's getting.
Yep. All right, real quickly, Danielle, what happens if both parties move to different states following separation, but not before divorce? And I'm assuming that they haven't filed for divorce yet.
Well, the divorce can be filed in any state or can be filed in the state in which once you've established residency there. So it typically takes 6 months to establish residency in a particular state. If only one party moves and the other party remains in the state where you were when you were married, then jurisdiction probably remains in the state where you lived when you were married. But if both parties have moved, I think that once jurisdiction, or once you've established residency after 6 months, I think either of you can file in that state, and then you just have to serve the other party and move forward that way.
And last one, Josiah, ex-spouse, soon to be ex-spouse, continues to file protection orders with no factual threat or contact. Could this be considered litigious misconduct? Also, our attorney is not responsive at all to any settlement or discovery. Is that also litigious misconduct?
So I'm going to address the second question first there, because that's a much easier question to answer, which is most likely yes. Failing to offer settlement, not necessarily, but definitely a failure to respond to settlement offers and a failure to provide requested discovery and disclosures is something that the court would consider in misconduct during the case, litigation misconduct, and an award of attorney's fees. As far as the request for a protection order, that goes back to the groundless, frivolous, and vexatious argument. Here in Colorado, in order to get attorney's fees on that, you would have to show that the original filing was either groundless, frivolous, or vexatious. And there are those are legal terms of art that have very specific meanings here in Colorado. If that finding can be proven, then yes, you can collect attorney's fees for having to defend against that protection order. However, if the court finds that there was a good faith basis, even if that was an incorrect assumption, if there was a good faith basis for the filing of the original protection order, that would make it very unlikely that there would be an award of attorney's fees in a situation like that.
All right, well, that's all the time we have. So thank you for joining, and thanks to the panel. You can find out more information by going to cordellcordell.com, 866-DADS-LAW, or in the UK, cordellcordell.co.uk. You can schedule a consultation virtually, on the phone, or in person where appropriate. You can get more information as well. Look for our next virtual town hall in November, but also don't forget to subscribe to our podcast. You can find out more information also in all of our past podcasts and town halls on our YouTube channel, the Cordell & Cordell YouTube channel. You can search that on the web and find out for information and a topic that's relevant to you, and just continue to educate yourself. So until next month and until the next podcast, have a great week.